Hello, everybody, and welcome to CMAC's Know Your Rights event. My name is Lisa Talley, and I am the Education Coordinator for CMAC. And for those of you who don't know, CMAC is a nonprofit organization located in downtown Fresno. And our mission is to help the community tell their stories. And one of the ways we help people tell their stories is also by making sure that they have the skills that they need to utilize cameras and other digital media equipment to tell the stories in the ways that make the most sense to them. And sometimes telling those stories also require engaging with the community and documenting what's happening in our community. And that may also involve also documenting encounters with the police and other law enforcement. So joining us with us today is Logan Tennerelli and Megan Hopkins, who are going to walk us through some very important information that is crucial for people to know about their individual rights. I'm going to go ahead and toss over to Megan.
Hi, and thank you for having us today. I think that this is an excellent topic and an important topic, and certainly a timely one. Just to quickly introduce myself, I'm Megan Hopkins. I'm an assistant federal defender with the federal defenders in the Eastern District of California. We have offices in Bakersfield, Fresno, Yosemite, and Sacramento. And I started with the office in 2014 in Fresno. I'm currently working in the Sacramento office. And I primarily practice in federal criminal legal defense, but there are a lot of crossover. It's mostly constitutional law practice, I would say, and statutory practice, but there's also a lot of crossover with immigration work. And we frequently deal with educating our clients on how they could have better enforced their rights with law enforcement and asserted their rights with law enforcement, and what we can do on their behalf after their initial arrest and the initial charges to enforce those rights.
Hi, I'm Logan Tennerelli. Thank you to everyone for coming today. I am Dean of Students at San Joaquin College of Law, and I also teach the Law and Democracy course at Fresno City College. Fresno City College is part of California Law Inc., which is a pathway to law pipeline designed to increase equity and diversity in the legal profession in the state of California. So if you're interested in learning more about Cal Law Inc. or City College or San Joaquin College of Law, I encourage you to visit the websites or feel free to reach out to me. And we actually have our upcoming Law School 101 night at San Joaquin College of Law on June 15th at 6 p.m. You can register through our website if that's something you're interested in, or if you would like to hear from current law students about their law school experience.
And I want to say before we get going that nothing that Professor Tennerelli, Logan Tennerelli, or I are going to say today represents necessarily the views of CMAC or of our employers, the Federal Defender's Office, the San Joaquin College of Law, or the Fresno Community College, and that we're legal professionals. We're not your lawyers, and this is not meant to be legal advice. These are our opinions as professionals in the field, and we're hoping that you walk away with some of your questions answered and hopefully new questions born from this conversation. But if you do want specific legal advice regarding a particular situation, you should consult with an attorney.
So how we're going to roll with this today is we absolutely invite the public to drop their questions in the chat if you're inside of the webinar. If you are watching on Facebook, please drop your questions into the comments. We do have people moderating those and keeping an eye for questions. And then at certain points during the discussion, I will take those questions and bring them to our presenters. Some of the questions also may be best for towards the end, which there will be a time that we can do an open Q&A. So again, drop your questions in the chat and add them to the comment section if you're viewing on Facebook. With that in mind and out of the way, to get things started, can each of you speak briefly about your goals for this discussion today?
Sure, I'll kick off. My hope is that, walking away from this conversation today, people feel empowered because they have a better understanding of what their rights are. They feel a greater sense of safety and security in asserting those rights and understanding the not only the history supporting those rights, but also the way in which they can be asserted safely and effectively. And then ultimately that burgeons a better relationship between our citizens and law enforcement, because it all works better when rights are asserted and then are respected.
Absolutely. I second that. I think a goal of today is not only informing people of their rights, but helping promote accountability and combating, over policing of certain communities or any systemic racism. With that said, I have many law enforcement officer friends. I know that many are out there doing a wonderful job, and the goal of filming any police encounter is simply to observe and to have to document what happens. Hopefully, I think most of us are on better behavior if we're filmed doing our jobs. So the goal is to prevent something from happening, not to, witness anything or go viral with something. The best possible outcome is that everything goes smoothly and rights and police protocols are enforced and that everyone stays safe. That being said, I also want to say that your decision to film police is a personal one. It can be influenced by your race, age, class, the neighborhood you're in, the time of day, your own criminal history, your own legal status. So by no means am I saying that everyone needs to do this. Please take into account your own experience and your own risk assessment of the situation. Filming police can have negative consequences in the form of online harassment, or you can potentially be putting yourself in danger if there is an armed person there. It can be very traumatizing. It can be very uncomfortable. I know that some of the discussion might be uncomfortable, but I think it's an important one for us to have respectfully. And I definitely welcome anyone to ask questions or share their views as well.
Awesome. So to get into the discussion, let's talk first about why filming police encounters and knowing your rights is so important.
I think in particular in the wake of the trial of Derek Chauvin for the death of George Floyd, that we saw how Darnella Frazier, who was a 17-year-old out shopping with her 9-year-old cousin, was able to film the entire 9 minutes of the incident. And not only was that footage, but her own testimony used very effectively at trial. There were other bystanders as well who were filming or who tried to intercede, tried to call in reinforcement or police officers. And there were the prosecutors of the case, who I think are a great demonstration of how anybody in any profession can promote justice. This isn't, of course, the first time that there have been civilian witnesses effectively. 30 years ago, during the beating of Rodney King, someone stepped out onto an apartment balcony, got out a handy cam, which is a huge, bulky camcorder, and started recording the incident, which also sparked national outcry and a public discussion. I think for a lot of people, particularly if you are not in a marginalized community, had trouble believing or understanding what that experience might be like in someone else's shoes. And now with the ubiquity of cell phones, we have greater awareness of what is out there. There's a stream of videos all of the time that people can view. So I think it's important not only to create a document, but to further public discussion as well of these issues.
Absolutely, I completely agree. And I do think that it's important to provide an opportunity for people who have been victims of brutality or who see themselves as being persecuted by the police, a greater sense of security in their communities. And the more of us that are out there observing and holding accountable law enforcement, the greater sense of security these communities will have. And so if you're in a place, particularly of privilege, where you don't face necessarily the severe collateral consequences of stepping up to observe these interactions, it's something you can do that can have a significant impact on your community.
Absolutely. And it can even, protect law enforcement officers from a false accusation of liability or excessive use of force for people to be there filming and just, observing what is happening. It's objective evidence, right? That we can all look at. We might view the same video differently, but we have important information about the length of time, what actually occurred, how a civilian was acting during an arrest or traffic stop. So we have something to go off of. In the trial of Derek Chauvin, I know the prosecutors praised the witnesses and said, you can see it for yourself without all of the lawyer talk. And in general, police reports are taken as they are and given a great deal of deference. So having a second account can only further information.
So is there a First Amendment right to film police encounters? And then if there is, are there any limits to that?
So yes, your right to film a law enforcement encounter is protected by the First Amendment. It's a part of your freedom of speech, your freedom to broadcast. And although the Supreme Court hasn't specifically weighed in on it yet, in fact, they've declined to grant certiorari on this issue, most of the circuits have agreed. The First Circuit, Third Circuit, Fifth Circuit, Seventh Circuit, Ninth Circuit, which is our circuit, yay, Ninth Circuit, and the 11th Circuit have all agreed that this is a protected right under the First Amendment, and that we have the right to broadcast and disseminate information, and creating the recording is part of that process of disseminating that information. If you're prevented from making the recording, then you're essentially prevented from broadcasting the information, which is the core of the protection there. And that's not to say it's not without caveat. There are certain requirements in California, for example, under Penal Code Section 647, you're not allowed to film law enforcement with a concealed recording device. So you want to record openly and notoriously, hold it up. You don't necessarily need anyone's permission to record. You're not asking law enforcement, do you consent to my recording you? But you want to make sure that they're aware that you're recording so that it cannot be argued later that that's inadmissible in court or that you've committed a crime by concealing or surreptitiously recording law enforcement. You also want to make sure that your recording does not interfere with their official duties. That would also be a misdemeanor, and it could give them cause to detain you or arrest you and charge you. And so you want to choose, like with most First Amendment cases, the three key words are time, manner, and place, right? So choose a location that's a safe distance that doesn't interfere physically with what they're trying to do. Choose a location, of course, that gives you a good vantage point so that you have a recording that's effective, that actually depicts what's occurring rather than is partially obstructed. And you want to choose how you act in that recording, whether or not you're actually engaging with law enforcement and communicating with them based on the circumstances. In most cases, you would want to simply record silently and not engage with law enforcement verbally while you're recording.
Yeah, I was just going to add briefly to that as well, that most people know their First Amendment right, but all constitutional rights have some limits, as Megan said, based on, public interest and safety or any governmental interest. There's always sort of a balancing test there. But the First Amendment not only includes our right to scrutinize and criticize government and question the government, but also the right to freedom of the press. And that doesn't just apply to certified, official journalists or journalists with any company. It applies to all of us as citizens. So when we are recording, we are acting as press in that capacity. And especially today, it's much easier to share that information on social media or through some other options that we will discuss later. But it's now easier than ever for anyone to shoot a video, and depending on what it is, an entire nation to see it.
And what I say sometimes when I have people say, well, really, it seems inappropriate that people should be able to record an officer in the middle of their duty. I ask them, would it feel inappropriate or something that the government could prevent if you were just standing on the side of the road taking notes, right? Taking notes about what was said, what was happening. If you can feel comfortable standing on the side of the road with a notepad taking notes about what you're seeing, you should feel comfortable recording.
So we do have a question that popped up, and it was somewhat answered in Logan and what you were saying, but the question is, do we need a media press pass to do this? And you're saying, no, we absolutely do not.
You definitely do not. I would encourage anyone interested to look into the National Lawyers Guild observation training, and then you can say, you know, I'm an observer. I have been certified through the National Lawyers Guild. There are a number of organizations that do it as well. Berkeley Cop Watch is one. So I encourage people to do that, not only so that you know your rights, but so that you might feel more confident in doing so. It can definitely be intimidating, even for me as an attorney. There are times I've felt uncomfortable recording incidents. So I encourage people to do that, but you absolutely do not need anything official to be there and take out your camera. I'll add some caveats to that later in this discussion, but you cannot break another law. So you can't trespass, you can't stalk, you can't harass police, you should not bring any weapons with you, you should not bring any drugs with you, you can't interfere with an arrest. So definitely there are things I would encourage everyone to know and to learn more about after today, but you don't have to be official media, you don't have to be over 18. Anyone is welcome to record in public.
There is also a follow-up question from that, but instead of sort of the citizen witness version of us recording the encounters, do we have the right to ask for dash cam videos as well as the footage off of body cameras?
So, you know, I mean, that depends, right? It depends if the law enforcement, it depends on who's asking. And it depends on if the law enforcement encounter resulted in a citation or in an indictment or charge in a complaint. So if you're a defendant facing a complaint or an indictment, or even a citation in the instance of a traffic citation, you do have a right to discovery. There are discovery rules based on jurisdiction. And you, if representing yourself or your attorney, would engage in that discovery process and make those requests. And typically, camera footage or lapel worn audio or camera footage from an incident would be discoverable. It's relevant, it's material, it could be exculpatory. But if you're a citizen observer that's recording and you want to request a copy of the dash camera or body worn camera footage from the officer you recorded, for example, to compare footage, you will likely not be entitled to that. I don't want to say under no circumstances. I'm sure there are 1983 civil rights claims that would give you discovery rights to that information if you were arrested or detained in the course of filming. But just generally, you would need to have standing either as a defendant or a plaintiff in a civil rights claim to get that.
I was just going to add that if you are personally pulled over, even if you don't get a citation or, you know, it never comes to the level of gathering evidence, you do have the right to ask if the officer is wearing a body cam and if that is on. Someone asked, what if these requests are refused? There are times, you know, a camera might not be working, you know, it's important for you to note, but there isn't necessarily anything you can do in that particular moment. If you yourself are pulled over, you can record. Generally ask the officer, do not reach in your pocket for a cell phone or anything like that that could be, you know, misconstrued as a threat. And you want to set up the camera not in your hand, somewhere else, so that you can film the entire thing and tell the officer that you're doing so.
And I would say that it would not be uncommon, and I would not be surprised at all if people assert these rights, make these requests calmly and reasonably and articulately, and they are refused by law enforcement. Law enforcement officers are learning along with the rest of us. Many of them have training and experience that conflicts with the sort of paradigm shift that we need greater transparency and accountability amongst law enforcement. And some are going to be in a mood where they don't want to comply. So, you know, in those instances, it's important to remember to assert your rights clearly. Make sure that you're, you know, creating a record, even if it's just verbally, that you're asserting your rights, but you're not in a position at that point to enforce them. Enforce them in a court of law through counsel, hopefully, after the fact. but you want to make a clear record on your own behalf that you've asked for these things to be done. You've asked for any body worn camera or dash camera to be turned on, that the incident be recorded to the extent the officer is capable, and that you be permitted to record if that's what you want to do.
So there was another question in the chat that, to be clear, there's no need to have a lawyer present or to ask for that footage for you, that you as an individual can do that.
So yes, people are always able to represent themselves in legal matters. And so if you're making a legal request for the footage in the discovery process, then you can do that on your own behalf. Or if you're represented by counsel, I would recommend letting counsel do that, just because typically attorneys in the field will have greater experience into how to make the request as broad as possible, how to ensure they're getting the specific discovery they're looking for, and how to identify if there's other discovery out there that they would want to investigate for. If you are not in a position of standing to request discovery as a plaintiff or as a defendant, then you can still make those requests on your own behalf. I would make them directly of the agency and state some reasons.
And if you have been arrested on a criminal matter, this obviously isn't true for, a traffic citation, but you are entitled to a free public defender. We'll talk later about how you can request an attorney at the time you are arrested right away, but it's unlikely, you won't end up in criminal court without an attorney there for you. So you will have a means to ask for discovery of any information.
So I'd like to move to our next topic. And while we may not be able to get to everybody's question as you're asking them in the chat, I would request that you please hold on to them, because there will be a time towards the end where we have an open Q&A session. So moving on, while we are focused today on filming the police, can you speak more broadly about your rights if you are personally pulled over or arrested?
Sure. So, I think it all comes down to my three favorite constitutional amendments, which is the 4th, 5th, and 6th. So you have a 4th Amendment right against unreasonable search and seizure. That means that an officer would need reasonable suspicion to make initial contact with you. They would need probable cause, which is greater than reasonable suspicion. I can explain those a little bit, in order to detain you, arrest you, or search. And this starts right at the initial contact. An officer shouldn't even be pulling you over or approaching your vehicle, or you as an individual on the sidewalk, unless they have some reasonable suspicion that needs to be particularized and articulable. That means they have to be able to point to it, the specifics of what led them to believe that they had a suspicion that was reasonable that criminal activity was afoot. That's the language from the Supreme Court case that really set the precedent here, which is Socolow. There's an additional Supreme Court case, Terry versus Ohio, that says that the reasonable suspicion articulated by the officer needs to be more than a mere hunch. It can't be that guy looked really guilty, or I got a feeling, right? And I've got lots of experience, so my feelings tend to be on point. They have to be able to point to something that they observed that objectively looked as if criminal activity was afoot. Then they get to investigate. That's when they get to make their initial contact. That's when they get to ask opening questions. But that's also when you as citizens get to assert your 5th Amendment right to silence. And that's when you start thinking about your 4th Amendment right to whether or not this seizure, the stop and detention of your person, is reasonable, and whether or not you want to agree to consent to a search, because that's another right that you have, not to consent to any searches. And officers have a very high bar to meet in order to search a vehicle or to search your person. And so asserting that right and declining to consent to searches is a way to assert that right. Probable cause can be triggered as easily as a traffic violation. If you commit a traffic violation, then the officer would have probable cause to determine that you'd violated a law of the state of California and stop your vehicle. But absent a specific traffic violation, for example, If you're just moving and shifting within a lane and an officer determines that's reasonable suspicion that you may be driving under the influence of drugs or alcohol and chooses to stop you, they don't yet have probable cause. They have not confirmed that suspicion that you are under the influence and that they can detain you or cite you for a DUI. And so now the ball is really in your court to assert your rights, your right to silence. I would highly recommend people not answer questions on the roadside for officers. You are required to provide proof of insurance, proof of financial responsibility for the vehicle. You're required to provide proof that you are a licensed operator of the vehicle with a valid license in the state that you're operating in, depending on the laws of the state. But you are not required to answer any questions about where you're going or where you're coming from or how many drinks you had with dinner or whether or not you're under the influence of any drug or alcohol. You're not required to answer any questions about your immigration status, about your age, about anything else about you or your travel plans or your travel history. And officers can certainly ask, they can ask for anything they want. It's about us not giving it to them if we don't feel they're entitled to it and we're not comfortable sharing that information. And I would say hedge on the side of don't be comfortable sharing the information because officers can misinterpret things that we say. They also are looking for, when they're asking these questions, ways to establish probable cause to move forward with an investigation that may ultimately result in your arrest. They have a job to do. They're investigating criminal activity. You need to understand that when you're interacting with law enforcement. They're also there in many cases to help. Sometimes they stop on a welfare check, but that purpose of the interaction can shift very quickly the minute they become suspicious that there's any criminal activity occurring. So my recommendation is to exercise those rights. Don't consent to searches. Don't provide additional information that they're not entitled to. And, the number one way to move things along with law enforcement when they're asking questions you don't want to answer is just simply ask if you're being detained or if you're free to leave. If you ask if you're free to leave, an officer is now in a position to determine whether or not they're detaining you, and they can only do so with probable cause.
Yeah, there are also some limitations. There's no set time on how long you could be, stopped at a traffic stop without being detained or arrested. I think a general rule of thumb, would you say, Megan, around 15 to 20 minutes?
I would say so. That, the more zealous advocates among us will probably try to start your timer at 12.
Okay, yeah. And I was also just going to say, if someone is asking to search, that doesn't mean you're under arrest. It doesn't mean that you will have been Mirandized. You won't have, right? Most people know their Miranda rights, that they have the right to remain silent. They have the right to an attorney. If they can't afford one, one will be provided by law. None of that will happen until the arrest phase. So don't be waiting to hear that if you're asked questions or asked to consent to a search. The officers have the right to ask you anything, but that doesn't mean you have to answer, and it is up to you to assert those rights.
Absolutely. You are not entitled to the Miranda warnings unless you're being interrogated. An interrogation means that you're in a custodial setting. That means you've been detained. You're not free to leave. And you're being asked questions the officer expects will elicit an incriminating response. So if the officer just says, hey, where are you coming from? And you say a bar, that's a voluntary statement on your behalf. It's not a Mirandized statement. You weren't entitled to Miranda yet. And they're going to ask follow-up questions. And the more questions you answer, the more questions you're going to get. And before you know it, you might find yourself making statements that are against your interests, and you have a right not to do that. And I would recommend that you assert it.
I would also caution against giving false information, even if it isn't necessarily illegal in whatever context you're in. It's not going to lead to anything good. I'd also encourage people to be, polite, respectful, calm. All of that will make the situation better for everyone, even if you are angry or upset, or even if, you believe your rights are being violated, you believe you're being arrested without probable cause. It is not worth putting your life at risk to assert that right in the moment. The officer is going to go with their judgment of what the law is in the situation. And your goal is to document it and fight it later in court with your attorney, not to make things more hostile or create a scene. That will not get you out of being arrested and will not make things better.
Absolutely. I completely agree. You want to be clear. You want to have conviction when you assert your rights. But once you've asserted your rights clearly and articulately, then you have to stand down and let the officer do what they're going to do. And you know that you've preserved them for a later argument in court if they're not being honored during the interaction.
And we had a question from the audience where they said, what verbiage would you suggest to use to refuse to answer a question? First of all, if you've provided your ID and your insurance information and your vehicle title, you don't need to say anything, right? You don't need to say a single word. I know that can be really uncomfortable, but I would recommend saying something like, I'm not gonna answer any questions. Am I under arrest? Am I free to go?
I would agree with that. I would, I think you can say, I appreciate it, officer, but I'm not going to be answering any questions. Am I free to leave?
And remember that if you do start talking, either if you're pulled over or even if you're being interrogated, the fact that you've started doesn't mean you have to keep going. It is pretty impossible, as Megan said, to dig your way out of a situation. So if you've started to answer questions and now you're uncomfortable with where the line of questioning is going, you can absolutely stop at that point.
I would say, just as a follow-up on that, the same is true with searches. If you've consented to a search and then you remember this talk and think, I was told that that's not a good idea, you can always revoke consent. Now, the sooner you do it, the better, because once the search begins, if the officer identifies anything that's incriminating, that might give them probable cause to continue their search, even without your consent. But just because you said, yeah, sure, go ahead and look in the trunk, doesn't mean you can't say, actually, I've changed my mind and I don't consent.
Yeah, absolutely. And, if you have an open bottle of vodka in plain sight, or if you have an illegal weapon in plain sight or illegal drugs in plain sight, I think most people know this exception, right? But then you are giving probable cause or something pretty close to probable cause, depending on the circumstances. Likewise, if an officer asks you, do you care if I look in the trunk? And they are looking for drugs and they find an illegal weapon, that is fair game in that case. Same with a search warrant. If someone is searching your home, the search warrant is very specific about what they can do. But if they see something in plain sight or find something else illegal when they are looking in the place they are allowed to look under the search warrant, that can be seized.
Great, yeah. And on this topic, are there any important United States Supreme Court cases or statutes that people should be aware of?
Yeah, I would say I'll start with statutes. There is a California rule that I think is very important. And I believe it's Penal Code Section 851.5A. And it says that you get to make 3 completed calls upon booking, and it should be immediately upon booking. So if you are arrested, the I get a phone call rule, it's a real rule. You can assert it. You're entitled to 3 calls, and they're 3 completed calls. So if you call someone and they don't answer or it doesn't connect, you get to make 3 completed calls. And so I would certainly make that request early on. I think that's an important statute, because if you're in the course of an arrest, and especially if you feel that your rights have been violated in the course of a stop, seizure, or search, then you're going to want to get in contact with people right away and mobilize individuals to start documenting things, to make the request for return of property, and to contact an attorney right away so that they can start protecting your rights and asserting them. In terms of important court cases, I mentioned earlier Terry versus Ohio, that an officer needs more than a mere hunch. United States versus Sokolow is a Supreme Court case from 1989 that says that an initial contact requires reasonable suspicion. If an officer is going to approach you and begin an investigation, they have to have an articulable, reasonable suspicion that you're committing a crime in order to do so. The exception to that is a welfare check if they believe that you're in danger of harming yourself or others, or if you're under the threat of harm, then they can engage with you as a welfare check. But that should be short and have a very limited scope. And the minute it converts to an interrogation or an investigation, they need reasonable suspicion to continue that communication with you. Another important case is Wilson versus Arkansas. That's 1995 Supreme Court case. It requires officers to knock and announce themselves if they're serving a warrant. It's very important that when someone knocks on your door, you know who's there. Officers shouldn't be kicking down your door, waving a warrant in your face without knocking and announcing themselves and giving you an opportunity to answer your door as a clothed person that knows what's going on, take a look at the warrant and let them in. And I would say, you know, with regard to what Logan was saying earlier with the duration of the stop, an important case from 2015 is United States versus Rodriguez. It says that an officer only has the amount of time that it takes to complete the traffic stop and issue the citation during a traffic stop. They cannot prolong their investigation beyond the time that it would take to issue the citation. So if they want to ask you questions while they run your license, they can ask you questions while they run your license. But when they've got the citation written up and they have everything they need and they're handing you back your documents, you should ask if you're free to leave, because you are.
I was going to add briefly to that information from Megan. I was going to add that when you make your 3 phone calls, you may not have your cell phone. I know in today's day and age, I have very few, if any, numbers memorized, but you might want to try to memorize some of those in advance. Your jail calls will be recorded if they are with family or friends or a bail bondsman. They will not be recorded if they are with your attorney, but if you are calling family or friends beyond saying, this is where I am, I would not give any more details about anything that happened or anything you believe about the case, anything you were doing. I wouldn't, you know, badmouth the officers. I would just simply inform them where you are so you are not worried. You'd be surprised how many people give a lot of information over jail calls. I was also going to add with the knock and announce, I think we saw, you know, the significance of that in the tragedy of Breonna Taylor's death, where we have conflicting testimony from law enforcement officers and neighbors about whether police officers did announce themselves, or if so, how audible it was. But, you know, if you believe someone is breaking into your home and you are bringing a legal weapon, right, this is the sort of thing that an officer knocking and announcing is intended to prevent, so it can, you know, make things a lot safer for them as well.
One other case I want to point out for folks is Pennsylvania versus Mims. That's from 1977. And the Supreme Court in that case held that an officer can order you out of your vehicle for officer safety reasons during a stop. That does not mean you're under arrest. It's not considered a search or a seizure. And the Supreme Court very generously said in 77 that it's just a mere inconvenience to us as compared to the overwhelming safety concerns of officers. And so that has carried forward. We haven't overturned that yet. So if you are asked to step out of your vehicle, even if you don't think the initial stop was appropriate, even if you don't think they have reasonable suspicion, even if you don't think they have PC, you should step out of your vehicle. They have the right to order you out of it. And like I said, assert your rights and let your lawyer enforce them in court.
Someone asked if a police officer has the right to ask your race during a traffic stop. I would say no to that. I don't think you even should be asked that. They said, what if they want to fill it in on a ticket? You know, there might be something identifying on your license or identification in that way, but I definitely would not answer that question. And there is no, you know, legal right for them to get that information from you.
I completely agree. And I also think go ahead and give them an opportunity to get it wrong if they're writing it down on a citation. It'll be an interesting talking point down the line if you ever get them on the stand.
Another question that we had from Facebook is an officer allowed to reach into a person's vehicle without permission?
You know, if an officer is reaching into your vehicle, there would need to be a specific purpose, right? There are certainly circumstances I can imagine an officer would be able to reach into a vehicle without consent. For example, if you flee your vehicle and run from it and your keys are in the ignition, the officer is going to reach in and disable the ignition for safety reasons. But an officer is not likely going to be reaching into your vehicle to open up your dashboard and get out your registration. They're going to ask you to hand that to them. It's unsafe for them to be reaching into your vehicle, and I think they know that. But if that happens, I would just confirm with the officer that you're not comfortable with them entering your vehicle. Their entry into your vehicle could be construed as a search, and they don't have a right to search you without probable cause.
Another question. What if I'm being pulled over, but I'm alone in my car on a country road and I don't feel safe stopping my car?
So this is a question that I've gotten several times. I think that particularly in light of all of the information we have about police brutality and things that have happened in the course of interactions with law enforcement, particularly in communities of color, a lot of people are feeling unsafe about being alone with a law enforcement officer who's armed. Typically, you have a right to pull over in a safe location. That means that it should be well lit. It means that you should not be in a situation where you're in physical danger because of your car's location. People have a right to exit the highway if there is an exit within a reasonable amount of time from the time the officer first alerts you that they'd like you to pull over. You can pull over into a safe space. But if you're on a country road that's going to be stretching for miles and there's not going to be any exit or any change in the environment, then you're likely going to need to pull over. You can communicate to the officer after you pull over that you don't feel safe in that location, that you'd like to continue forward with them behind you until you get to a safe location, and ask them if they would like to direct you somewhere. And if that's more of a conversation that you'd like to have with the officer, then I would recommend you assert your Fifth Amendment right and stay silent during the interaction as much as possible and provide them only what you're required to do and end the interaction as quickly as possible. If you're in an uncomfortable space, if you're in an area that's not well lit, and if you're alone, all the more reason to ask if you're free to leave as often as possible.
I'm not sure, if the basis of the question was more feeling uncomfortable with law enforcement or fear of someone posing as law enforcement. Those cases are relatively rare, but I have heard of cases where that has happened. I would say, first of all, remember that police can operate as undercover police officers, right? So just because the car doesn't look like a typical police car doesn't mean that there is necessarily some sham going on or anything like that. I want to say I've heard that you can call 911 or the police station and make sure, it is a valid officer, but I'm not positive. I'd have to follow up briefly on that. I don't know if you have heard anything like that, Megan.
I haven't. I love the idea. I think that you would get, it could get sticky. Officers typically will, I would say, elevate their concern for their own safety the longer it takes for someone to yield to their request for them to stop. And I say that as a white woman who's had an officer pull a firearm because I didn't see them for a few minutes before I got pulled over on a traffic stop. And so depending on your personal experience, your safety level and comfort level, you may not want to extend the duration of a drive when you're being pulled over to make that call. But I think that I would have to look into it, but I would say if you're feeling unsafe, it might be worth making the call. You can always explain yourself to the officer later.
Someone also asked where to find an attorney if you believe you've been falsely arrested or injured in a false arrest. I would say we're going to give some resources at the end. The ACLU is always a good place to get started. I don't know if you have other places you would recommend, Megan.
I think there are attorneys that advertise themselves as civil rights attorneys, and that is the title that's the area of practice. This would be a 1983 civil rights claim. But yeah, I would always start with the ACLU.
So in knowing your rights, and while we're still on the topic of individual rights, what about respect to immigration and ICE warrants? I mean, I assume this could go on for a while and it could be its own topic and its own webinar, but is there anything people should know about those rights and how they differ from the rights you've already been discussing?
Yeah, I would say first, it's very important to know that individuals, whether or not they're legally documented in the United States or not, or they have a legal status in the United States or not, have Fourth Amendment rights, have Fifth Amendment rights, have Sixth Amendment rights, have First Amendment rights. The same rights apply in those respects. And specifically with an ICE warrant, I just want to say that's a misnomer. ICE warrants are not warrants. They're not signed by a judge. They are typically signed by an administrative officer within the Immigration and Customs Enforcement Division. They are authorized upon a notice to appear in immigration court. So it's not following criminal charges. It doesn't authorize entry into a home. In fact, that's probably the most important thing to keep in mind with these documents. This is not a warrant. It does not authorize a search of your private space or of your home. You can refuse entry to an officer serving an ICE warrant. So what I would do if someone hands you something and says, I have a warrant for this undocumented immigrant's arrest, if they found their way to using language that appropriate, I would say, let me see the warrant and let me see where the judge's signature is. If there's no judge's signature on there, it's not a warrant. You can hand it back and tell them to have a nice day, but they're not going to be entering your space. And absolutely under no circumstances are you required to reveal your immigration status, just as you're not required to reveal your ethnic or racial identification or how you self-identify. And so if someone asks you if you have papers, if you're legal, if you're a citizen, I would decline to answer that question if it were me. They're not entitled to that information. And I cannot imagine a way that that information would be used to the benefit of somebody. So I would recommend exercising that Fifth Amendment right, which we hold regardless of our status in this country.
Great, thank you. So we're getting towards the end of our webinar here, and I wanted to come full circle back around to filming encounters with law enforcement. And so for those of you in the webinar and are watching on social media, if you ask questions and you feel like we're not getting to your questions, we're not ignoring you. We're going to save those questions and we're going to bundle them up and ask them at the end for the Q&A. But right now I wanted to ask, what should people know about filming police encounters as civilian witnesses, specifically any tips about filming and the actual mechanics of filming in the moment?
Yeah, absolutely. I think we've covered a couple of these, but stay calm, stay respectful, avoid abrupt or sudden movements. Don't shout at the police officer or engage with, the police officer in any way. You can say something like, I'm just here to record. I am just witnessing. And then at that point, I would not answer any further questions, or you can say something like, I have the right to be here. Generally, you want to stand a safe distance away, especially, determine whether the audio is sort of more what you're concerned about or filming the whole scene. But, at least I'd say 10 feet away. If you're asked to move, take a few steps back or move to a different location and record yourself doing so. You also, if a police officer blocks your view with their vehicle or their body, simply move to another location and keep filming. Make sure you either announce that you are a civilian witness and recording, or that you have your camera very clearly out and that you are recording. It's best to film as much context as possible. So from the minute you decide to start filming until the minute you decide to stop, don't, just film a few minutes that you think will be the most significant, because the context can be important if that video is to be usable later. I would also note that if for whatever reason you can't or are not comfortable filming, there is still a chance that you could be asked to be a witness if there is a trial. So you want to, if possible, provide your information either to the civilian after the fact if they are not arrested, or to other people nearby. Potentially, you can even look into the court system or the case. You can ask the civilian their name if you want to try to help later. Of course, they don't have any obligation to tell you. I would also say, again, you have no right to interfere or to delay the officer. It can be a little bit murky what exactly constitutes interference, but if you are clearly agitating the civilian or making the situation worse, that's not your goal and you should stop filming. You definitely have no right to, be right in an officer's face or to block them or anything like that. I would say, if there is retaliation, which a few people have asked about, you may or may not end up having a claim depending on the circumstances. If you're falsely arrested or if you are, have your phone seized or something like that, maybe you'll have a case, maybe you won't. It's going to depend. Generally, there is a lot of deference paid to the officer's assessment of whether you're interfering. I would also encourage people right now to, wear a mask and make sure you follow safety protocol and do not identify an undercover officer. But in general, stay, you don't have any reason you have to talk to officers, stay calm, film as much as you can, know if there's any surveillance cameras nearby that might become useful later if needed.
And just a quick evidence plug from a practicing defense attorney, under the federal rules of evidence, in any event, present sense impressions are admissible even if they're hearsay. So if you're recording a video and there's important audio or there's narration that needs to happen and you're a safe distance out of earshot of law enforcement where you don't think that you'll be impeding their investigation or their interaction in any way by narrating, if you want to discuss in audio shot of your video what's happening and narrate, then if you are later unavailable to testify in court, that may be admissible by counsel as a present sense impression. So, or spontaneous statement or excited utterance. So consider if you feel like there's anything that's unclear or there's an important background that occurred prior to you starting filming to narrate a little bit on those videos. It can be really helpful to counsel.
Another thing, and this was something from an earlier discussion before this webinar, that there was importance about keeping your phone locked or having a passcode on your phone in the event that it might get seized.
Yes, I recommend to everyone to password protect your phone, whether it's a swipe password or a numeric password or whatever type of encryption you're trying to use. If an officer obtains your phone and is under the impression that you are not authorized to record, they may try to delete your recording. That would be tragic. So I would say to protect not only the recording that you've been creating, but also all the other information and metadata on your phone, which is highly personal and basically gives a window into your entire life. Password protect that device.
Yeah, I agree as well. In the event that there is a search warrant for a wire or something like that, anything backed up to your iCloud will be pretty easily discoverable. So consider if you want to use some sort of encrypted app like WhatsApp. However, you never know when they'll change their policy. You never know if someone on the other end is screenshotting what you say. So always be careful what you say in general over your telephone. It can create a permanent record, but if you are concerned about that, you might want to consider not using your basic text messaging.
And also, as part of the conversations that we've had previously, there was also mention of what to focus on when you're filming, who specifically to point the camera at, more so on law enforcement, more so on the person being detained or arrested. What would you recommend?
I generally say, camera on cops. You want to honor the civilian's privacy. Of course, if people are really close together, you'll be filming everything, but try to get a picture of the whole scene, how many officers are there, what the context is as much as possible. And I would say that's, who you should focus on when you're filming.
I would agree, with the exception of when the civilian's demeanor becomes relevant. If the civilian repeatedly says, I'm complying, and the officer that you're focusing on says, stop resisting, or one of the many taglines that we've heard, it might be a good opportunity to just pan to the civilian so that you have some video footage of the civilian complying, if that's in fact what they're doing. You remember that, when you're recording these interactions, you're not recording them to catch the bad cop, right? You're recording them to create a documentation of what occurred during this interaction. So if the interaction, in fact, is as the officer is describing, there's a benefit also to providing an accurate account of what happens. on either end. And so you just want to make sure that you're paying attention to the interaction and reacting to what's happening in terms of what you're recording.
Yeah, thank you for noting that. I have been in a situation where I've been recording and seen someone in over 100-degree heat, handcuffed, and appeared to me, dizzy or dehydrated or something like that. So definitely, I verbally noted that and filmed as well. So there are definitely situations where you might want to note something like that.
So we've got another question that came in. Am I allowed to record on my own interaction with an officer, and what is the best way to go about that without making the situation any worse?
So yes, you are absolutely allowed to record your own interaction with law enforcement. It's the same rules apply. You can't surreptitiously record. Don't use your James Bond pen to record your interaction with law enforcement. You want to place the recording device, which more than likely will be your phone or a dash mounted camera if you have one in your vehicle, in an area that will have a good vantage point. If this is a traffic stop, you can just put it up on your dash, point it towards yourself, and let the officer know that's what you're doing, that you're recording the interaction, so that they don't in any way argue it was concealed. If you do not have a video recording device and you just have audio, you can always record the audio. If you have the means, I recommend installing a dash camera in your vehicle, particularly if you are a member of a community that is disproportionately stopped by law enforcement and may have more frequent interactions with law enforcement. The camera will record automatically most of the time. The software has come leaps and bounds in the last 5 years. And so when the vehicle stops, the recording starts. If there's an impact on the vehicle for a traffic accident, the recording starts. And you can pick these up at Best Buy for under $100. And so if you're interested in recording interactions and you want to make sure you're able to, that's the best way to do it. If not, make sure you have your own device and you can identify it for the officer. If the officer says, I'm not going to let you turn that on or give me your phone, assert the right very clearly and then comply to avoid any ramifications that you can't undo in a court of law.
All right. So we're getting, so we're at the point now where we're going to open it up for last questions. If there was anything that you were hoping to ask and didn't get a chance to ask or asked previously and we hadn't yet asked that question, I will welcome you to drop those questions in the comment section on Facebook or right here in the chat if you are in the webinar. But while those questions are coming in, I would like to ask both of you, if people could take away just one piece of advice from today, what would it be?
Sure, I'm happy to start. Like Megan, I hope this gives you some answers, but keeps you asking more questions and that you continue to educate yourself on this issue, share what you've learned with other people. There was a time where I think, we thought a lack of police accountability or, police targeting of certain communities was simply an informational problem. But I think it now goes far beyond that. While I think filming police encounters is extremely important, that is not the entire solution. I encourage you to vote. I encourage you to use your First Amendment right to attend protests or rallies. Don't get violent, stay calm, but just to engage as much as you can in your community so that you are fighting for the issues you believe in.
I second all of that. I would be thrilled if that was the takeaway from today. Just to add to it, I would say you are the only person that can assert your rights. No one is going to assert your Fourth or Fifth or Sixth or First Amendment rights on your behalf. You need to do that to the degree that you're comfortable and in a way that is safe and effective. So be clear, be calm, have conviction, and knowing your rights is an important first step. That's what this is about, to help you get a better understanding. But if you walk away from this with questions, investigate, follow up, and get the answers that you need so that you are fully equipped to assert your rights. Your defense attorney, if you ever have one, will thank you. But you will be thanking yourself when you walk away from situations that could have gotten a lot messier, knowing that you did what you needed to do to assert your rights. There's a reason that these rights are protected by our Constitution. They're important. And we have, over the years in our history, fought for them continuously in and out of court. And so, hold them like the banner that they are. That's what we're here for, to help you do that.
So we do have another question that came through in the chat, and that was, do the same rules apply for all levels of law enforcement, like state or federal?
Yes, the 4th, 5th, and 6th Amendment and the First Amendment apply equally to any government agency. So whether or not you're being stopped by a sheriff or a local police department or the FBI or the CIA or ATF or anybody else, you have the same rights against unlawful search and seizure, unreasonable search and seizure. You have the right to silence. You have the right to counsel in the event of an arrest or interrogation. And you always have your First Amendment right to speak, to assemble, to record and publish and broadcast. So
I was going to follow up on that. Well, the Constitution applies to all government actors for the most part through the 5th or 14th Amendment. There are individual state rights. Megan cited some of them today. So rules about, surreptitiously recording or, something else might differ state to state. So if you move or would like to know your rights in an exact state, please look into that as well.
And another question just dropped in. Are you allowed to ask for clarification why you were being arrested without resisting arrest? And if you have no idea why you were being arrested, yes, are you allowed to ask for clarification?
So just like law enforcement is allowed to ask you anything they want, you're not required to answer. You are certainly entitled to ask law enforcement what the reason is for the initial stop or detention. Ask them if you're being detained, ask them if you're being arrested. That doesn't necessarily mean you're going to get an answer. Law enforcement doesn't have to specifically advise you of the reasonable suspicion that forms the basis of a stop. They also don't have to advise you of the specific information they're using to form probable cause for a search at the time. I think that an officer that wants to have a positive interaction probably would. Certainly, if you're being cited at a traffic incident, you're going to be advised of the citation, either in writing on the citation or verbally by the officer of what you're being cited for. But remember that you're not necessarily entitled to it. You're entitled to ask, not necessarily entitled to the answer. And the more calmly and politely you ask, the more likely you are to get information from the officer.
Yeah, I would just add to that, if I was pulled over or being arrested and had no idea why, and then was told something that I didn't think, was what happened, I would definitely feel the urge to argue and explain myself, but I would not advise you to do that, even for people who know their rights or lawyers or, anyone in this field, people in criminology. There can be a lot of pressure to either talk or to, stop recording or to start arguing because you're in the moment and you're probably feeling a lot of adrenaline, maybe fear, but just that's why it's important to keep reminding yourself of your rights so that you know what to do when the situation arises and, don't let the context itself get bigger than, the actual picture of what is the best thing for you to do.
And I think we have time for just one or two more short questions. Can officers lie to civilians?
So yes, officers can lie. In fact, as part of their training and interrogation, they're trained to lie strategically, to get reactions, to convince people that the story that they've been putting forward no longer has value or is no longer credible. I've seen cases where officers have told a suspect that they had DNA evidence linking them to a scene or to a person, that someone else had already talked to them and had pointed a finger at them. There are no ramifications to law enforcement for being dishonest with you in the course of an investigation or interrogation. So that's why it's important to know the facts yourself and keep them to yourself, and know your rights and assert them clearly. And really, the best way to defend against an officer lying to you to elicit an incriminating response is to assert your right to silence and not respond at all.
Yes, and assert your right to an attorney. Never sign anything until you have your attorney present. I would say, when someone is being arrested, an indication that, someone else has already corroborated this or named you, or we already have evidence of this, we already know. If you share more, we'll help you, but we just need you to tell the truth. All of that is extremely commonplace. I'm not remembering the name, but there was a famous case in law school about someone saying, something like, we just want to know where this body is so that we can do a Christian burial like her family wanted, knowing that the person in the back seat was, would be sympathetic to that. And the Supreme Court found that, yes, that is completely legitimate to say, even though it wasn't, the situation itself. So, don't lie back, because your statements can be used against you. Anything contradictory will be used against you, but don't assume that whatever they're telling you is true.
That's not to say, though, that if you're in a situation where you do have counsel representing you and you believe law enforcement did lie to you, or they made you promises, or they made you threats, that you shouldn't share that with your attorney. In some cases, certain promises or threats by law enforcement in the course of interrogation rises to a level of coercion, and then an attorney might be able to do something with that to shield you from charges or evidence. But best thing you can tell your defense attorney is, I didn't say anything and I asked for a lawyer.
Someone asked if you'll be arrested if you don't sign a citation, a traffic citation. You are not agreeing to any of the actual things alleged, right? You're not agreeing that you did anything. You're simply acknowledging that you got the citation and that you know of your right to appear in court. So I would encourage you to sign that, even if you plan to argue it and disagree with the officer's assessment of what happened.
Yeah, you can refuse to sign those. The officer is going to note that you refuse to sign, and typically the commissioner or judge that oversees your traffic case later is going to be mildly irritated that you refuse to sign. That's my experience anyway. So you're not giving up anything, waiving any rights by signing that. You're just acknowledging that you're aware that you've been cited, even if you feel that you have a completely viable defense. So I would say sign it. It also will help end the interaction with less communication with law enforcement if you sign.
We have one last question that came from inside the webinar. So this question is in regards to safety when around police. How can people have good rapport with police officers without feeling as if he, she, or they might be scared or afraid around police because of what has been seen on the media, such as on the news and things of that nature?
I think this is a great question, and I wish I had a better answer to it. But yes, particularly members of the BIPOC community, a trans individual, unhoused or homeless individual, it's very frequent to have either personal, negative experiences or a negative idea based on the experiences of others you'd have. I'd say, remember that a police officer might be scared in a particular situation too, legitimately or not. I don't think most police officers are out there to harass people. I think most of them are, in the profession because they truly want to help. Your feelings are legitimate. Just because you're afraid, I can't tell you not to be afraid. I would be too, but that doesn't mean that you can't calmly assert your rights. So, in general, the more people the more people we experience and get to know, we can be someone's, first encounter with a certain group that's going to be positive for them. And in general, I think the way I've seen people change their minds about a particular group is by knowing someone who's part of that group and realizing they aren't who you thought they were. That's not to say you need to go, try to be friends with a bunch of law enforcement officers if you aren't currently, but I guess I would say, I think it's noble that you have that goal. And, I wish I could better tell you how to deal with that. There are definitely incidents of officers upholding people's rights or prosecutors upholding rights, like in the case of George Floyd. So you can find counterexamples out there, but all of us, have use heuristics or judgment shortcuts based on our own experiences. That is natural. There are lots of things you can do to test implicit bias. There's like Harvard implicit bias testing, but I think just keeping in mind that the calmer you can stay, the better, but that your feelings are legitimate and valid.
I would say I completely agree, and I believe that the more information and a dialogue are important. And it's not always easy to have a dialogue with a law enforcement officer when you're engaged in a stop, and you're the subject of an investigation. But if you find yourself in a situation where you can have a dialogue in a casual setting where you're not the focal point with the law enforcement officer, there's a lot of value in that and in sharing your perspective. Even if you don't walk away feeling more educated, maybe you'll leave them feeling a little more educated about how you are experiencing law enforcement as a citizen. I think everyone wants to get along. And I think that many people go into law enforcement with the hope that they'll improve their communities. And I think some of that gets lost along the way, and some of it survives. And so I think adding as much fuel to the fire of building communities, strengthening communities, and protecting communities, which is important to all of us, will further that conversation.
Yeah, absolutely. And I was just going to add that as attorneys, Megan and I have probably met many people who have said, I'm scared to talk to attorneys, or I don't like attorneys. I've had negative experiences with attorneys. So, at some point you might find yourself as part of a group, if you aren't already, that, doesn't always have the best reputation. But again, the more people, you meet of a particular group or in a particular field, the more you might find that you have something in common, or you're able to reach a certain level of respect.
Well, Logan and Megan, I just wanted to thank you so much for all of this wisdom and advice and insight that you were able to provide, and for joining us this afternoon for this Know Your Rights webinar. I know that we're getting a lot of positive responses for it, and it's just invaluable information. So we really appreciate you taking the time out and joining us here today. We are, I apologize. Would you like to say anything else to our group and those watching out on social media before we close?
Just thank you for having us. I think that as much as our time here may be appreciated, I want you to know that I really appreciate all of your time. We're here to educate you, and it's a two-way street. So I really appreciate everyone taking their time to sit in on this and learn, and hopefully you can go out as ambassadors for this information and share it with other people.
Yes, I second that as well. And thanks to Megan also. She's a practicing attorney. I'm a professor. So, I am used to having this type of thing. So for you to go out and do that on your own time is very generous of you. And thank you to all of you for coming and for, caring about improving our community in the ways that you can and knowing your rights.
So we are going to put this whole session is recorded and will be available on CMAC's website. We'll also be streaming it on our own channels as well. And Megan and Logan have been kind enough to provide additional resources where individuals who are interested in learning more can go and do their own research and find where they can submit videos that they've recorded, what to do if they're in certain particular situation that we've talked about throughout this entire webinar. And that information is going to be at cmac.tv/know your rights. And with that, again, thank you to everybody who was here with us in the webinar, who's been watching out on social media. And of course, again, thank you to Logan and Megan. We appreciate having everyone involved today. Thanks for watching.